Yes, welcome all. Our meeting is now streaming live on YouTube. Without wasting much time, first of all, I thank you all participants for accepting our request and joining this important session. I would like to request our principal madam to give welcome speech. Over to you, madam.
Thank you, sir. Ma Saraswati la Vandan. Gokhale Education Society's NB Thakur Law College, Nashik, Maharashtra, is organizing national webinar series on different legal topics. We have discussed about viability of e-courts in India and post-pandemic approach to legal education. Today, we are going to have discussion on protection of fundamental rights of migrant workers during 19 pandemic and thereafter. Myself, Dr. Mrs. Asmita Vaidya, Principal NB Thakur Law College, Nashik, welcome you all in this national webinar. Friends, Gokhale Education Society's NB Thakur Law College has been established in the year 1969 and has given many eminent judges, lawyers, law educators, social workers, and political leaders to the society. This college is known for academic excellence, innovative activities, strict administration, and good infrastructure. We conduct seminars, conferences, workshops, short-term training program on research methodology, and national competition, as well as legal awareness camps continuously. We have conducted 100 legal awareness camps in Nashik in 2018 as a part of Gokhale Education Society's centenary celebration, making awareness of fundamental rights, human rights, women rights, rights of workers, senior citizens' rights, and so on. This college is famous for extension activities along with academics. Our college is pioneer in arranging moot trial and judgment writing competition at national level. We conduct near about 12 courses of law, 2 UG, 7 diplomas, 1 certificate, 1 postgraduate course affiliated to University of Pune, and 2 autonomous certificate courses designed by college. The college is NAC accredited in 3rd cycle very recently. During this period of lockdown, we conducted legal quizzes and started national webinar series. Friends, we are conducting so many activities because of continuous support and guidance from our management. Honorable Sir Dr. M.S. Gosavi, Secretary and Director General of Gokhale Education Society, is a person with vision. He is bestowed with more than 85 national and international awards. He is an outstanding international management scientist. He has set a world record of youngest principal with longest tenure. He is also bestowed with Shri Jnana Saraswati Award at the hands of Gan Saraswati Lata Mangeshkar and recently received APJ Abdul Kalam Gold Medal. On this occasion of 3rd National Webinar, I welcome Sir Dr. M.S. Gosavi, Secretary Gokhale Education Society, Nashik. I also take blessings of Principal S.B. Pandit Sir, Chairman Gokhale Education Society. I welcome HR Director, Principal Dr. Mrs. Dipti Deshpande Madam, Establishment Director Shri Shailesh Gosavi Sir, Zonal Secretary Dr. Ram Kulkarni Sir, Dr. R.B. Deshpande, Branch Secretary, and all the respected authorities of the society. As we know, the entire country is facing unforeseen outbreak of pandemic COVID-19, because of which we all are observing lockdown. The lockdown in India has impacted the livelihood of a large proportion of country's internal migrants. Around 60,000 and more laborers, workers, they moved from urban centers to rural areas of origin. Lockdowns, loss of employment, lack of livelihood facilities forced these laborers to go back to their native places. Fear of corona also forced them to go back. The mass exodus of migrants from cities has raised concerns over an impending economic crisis. What will happen to industries that are dependent on them for labors? And what about economic stability of these migrant workers? Further, the end of lockdown will likely to start a new phase of problems for migrant workers as labor exploitation may rise significantly. A nationwide lockdown has a disproportionate impact upon the livelihood of one set of people, that is migrant workers, and prima facie attracts Article 14. The second more obvious right is the Article 14 right to life, which includes right to livelihood. COVID-19 brings into sharp focus on the right to health also. Thus, many questions relating to rights of migrant laborers, protection of their fundamental rights, human rights, workers' rights arose. Today, in this national webinar, we are going to discuss on protection of fundamental rights of migrant workers during COVID-19 pandemic and thereafter. Today, we are have Justice Rajasekhar Mantha, Judge, Calcutta High Court, on this topic. After completing schooling from Kolkata, he did his LLB from Nagpur University College of Law, Nagpur University, Nagpur in 1990. LLM in Commercial Corporate Laws from King's College, London, University of London in April 1991. He represented South Asian region at the Commonwealth Law Conference held at Auckland in New Zealand as a part of South Asian Moot Court team in April 1990. Started practice in 1990 in Kolkata and has practicing in inter alia, commercial corporate, finance, securities, constitutional, consumer protection, and environmental. He was designated as senior advocate in 2015 July. He was visiting professor to the National University of Juridical Sciences at Kolkata and have delivered lectures at the Staff Training College of various nationalized banks, the CIT West Bengal, the Institutes of Chartered Accountants, Kolkata. He is elevated as an additional judge of High Court at Kolkata on 21st September 2017 and appointed as permanent judge in September 2019. Sir, on behalf of Gokhale Education Society and Inbi Thakur Law College, I welcome you. I once again welcome all the participants from all over Bharat, honorable judges, lawyers, law teachers, and students who are with us. I now request Honorable Justice Rajasekhar Mantha, sir, to address us. Thank you. Over to you, sir.
A very good morning to everybody. Am I audible to you?
Yes, sir.
Yes, sir.
I thank the Law College for having invited me for this webinar. The topic is burning. The topic is in front of all our eyes. There are lawyers, law students, judges, the government, establishment, and everybody concerned about these migrants. So we have chosen this topic, fundamental rights of migrant labor during COVID-19 and the pandemic and thereafter. Going straight into the subject, the COVID-19 virus has been declared by the World Health Organization as a pandemic. The central government was forced to declare a complete lockdown of life and business in the whole country since the third week of March 2020. Nearly all sections of society have been affected adversely. Migrant labor have been found particularly hard hit without work or food and far away from their hometowns. The COVID-19 crisis has forced India's attention to the plight of migrant labor. For decades, millions of workers have moved from state to state and some to shores abroad in search of livelihood. Images of millions of Indians walking hundreds of kilometers, some even losing their lives in the attempt to go back home, has shocked the nation and has exposed the severity of the impact of the lockdown on migrant labor. Similarly, the economic impact of Indians being forced to return from abroad amidst the collapsing economies in the wake of the pandemic is expected to be felt in the coming months. Close to about 500 million Indians today are internal migrants, either living in a place where they are not born or did not live 6 months ago. So we are talking about 150 million plus people in the country who move from their home state to another state for work. The basics are, who is in fact a migrant laborer? The term migrant is defined in the Cambridge Dictionary as a person that travels to a different country or place, often in order to find work. Migrant labor is also defined in various statutes, which we shall address at a later stage in the discussion. Those who move from one state in the country to another seeking daily employment are migrants. They move from any place where there is no source or chance of employment to where there is not only employment available, but also a likelihood of employment or engagement. The purpose is to earn livelihood, mostly temporary or semi-permanent in nature. Most of it is daily wage work. Generally, there are two basic factors related to migration. One is distance. The second part is duration of engagement. Post-liberalization, India witnessed a large-scale internal labor migration. These migration routes, often from the east to the west of the country, rely on kinship networks. Take, for instance, the Kendrapara district of Orissa. It is called the plumbing capital of India, as migrants from this region dominate the plumbing labor force in large cities across India. From a distance point of view, migration can be classified in four categories: rural to rural, rural to urban, urban to rural, and urban to urban. Besides, migration can be divided in the following categories: intra-district, inter-district, intrastate, interstate, national, and international. From a duration point of view, migration can also be divided into casual and or temporary, periodic and or seasonal, and permanent migration. The general categories of migrant labor are load bearers, coolies, masons and building workers, carpenters, cooks, electricians, plumbers, sanitary workers, agricultural laborers, welders, fitters, etc. The semi-skilled or partly trained workers in factories. In the unorganized sector, there are bamboo cutters, there are sal seed collectors in Orissa, the fishermen, the leather flayers, the tanners, the salt workers, and the beady workers, the handloom weavers, the hand craftsmen, the workers in brick kilns and quarries. According to the 2011 census, India has about 5.6 crore interstate migrants, most of who come from the Hindi belt of Uttar Pradesh, Bihar, Jharkhand, Rajasthan, and Madhya Pradesh. A majority of such migrant work is in the informal and unorganized sector. A large number of daily wagers without any form of valid identity documents given their transient existence. This is the kind of migrants that we have. Notably, while the number of interstate migrants grew from 55% between 1991 to 2000, it came down to 33% from 2000 to 2011. Most migration nowadays happens to places like Delhi, Maharashtra, Gujarat, Andhra Pradesh, Karnataka, Telangana, and Tamil Nadu. In a sense, the northern parts of India, except Delhi and maybe some parts of Rajasthan, mostly migrate towards the south and the west. Why has there been such huge movement during the pandemic? First thing is loss of employment during the lockdown. Loss of shelter and food source. Hoping to go home at a time of crisis and come back later or move to a different place of employment. Chances of finding some food or succor at home. Insecurity from the lack of awareness of statutory rights. Apathy of the states where they migrant labor are employed, and the failure of the states to enforce the existing statutory provisions. We shall discuss the statutory provisions at a later stage in the paper. Let us first therefore examine what are the constitutional provisions to protect these migrants. We shall examine the existing statutes at a later stage. These statutes are based on these constitutional provisions, which have seen expression in various decisions of the Supreme Court. The directive principles of state policy and the obligation cast in the state. You must first understand that the right of these migrants have not found place in Part 3 of the Constitution, that is fundamental rights. Their rights can be traced out primarily to Part 4, which are the directive principles of state policy, which cast more of an obligation on the state. Article 38 provides that the state should strive to ensure the welfare of people. Article 38(2)(e) says the state shall endeavor to minimize inequalities in income status engaged in different vocations of people, obviously. Now, Article 41 says the state shall, within its economic capacity, ensure the right to work and education. According to the directive principles of state policy of the Indian Constitution, therefore, the state is required to secure for the citizens, both men and women, the right to an adequate means of livelihood, the equal pay for equal work for both men and women, protection against abuse and exploitation of workers' economic necessity, protection of their health and strength, to secure for children opportunities and facilities to develop a healthy manner, in a healthy manner and in conditions of freedom and dignity, and protect children and youth from against exploitation, moral and material abandonment, to secure equal justice, free legal aid, to make effective provisions for right to work, to education, public assistance in cases of assistance, to ensure just and humane conditions of work and maternity relief, to secure work, a living wage and a decent standard of life to participation of workers and in management and things like that. Let us therefore now, in the background of these directive principles of state policy, see how the Supreme Court has looked at, how courts of law have looked at the rights of these migrants. In Mann versus Illinois, it's a US Supreme Court decision. It's reported in 94 US, page 113, a decision of 1877. The US Supreme Court referred to the observation of Justice Field, and he was quoted to say that by the term life, as here used, something more is meant than mere animal existence. Thus, it embraces within itself not only the physical existence, but also the quality of life. In Khadak Singh versus State of Uttar Pradesh, reported in AIR 1963, Supreme Court, page 1295, the Supreme Court, approving the views, the observation of Justice Field, had said this: by the term life as here used, something more is meant than a mere animal existence. the inhibition against deprivation extends to all those limbs and faculties by which life is enjoyed. The provision equally prohibits the mutilation of the body by amputation of an armored leg or pulling out of an eye or destruction of any organ of the body through which such soul communicates with the outer world. So, if you see, right to life also therefore includes something more than mere animal existence. It has to be a human life is what the Supreme Court recognizes. Coming to the right of employment and livelihood, in Delhi Development Horticultural Employees Union versus Delhi Administration, reported in AIR 1992 Supreme Court, page 789, the Supreme Court held that broadly interpreted and as a necessary logical corollary, the right to life would include the right to livelihood and therefore the right to work. But this country has so far not found feasible to incorporate the right to livelihood as a fundamental right in the Constitution. This is because the country has so far not attained the capacity to guarantee it, and not because it considers it any less fundamental to life. Advisedly, therefore, it has been placed in the chapter of Directive Principles of State Policy under Article 41, of which enjoins upon the state to make effective provisions for securing the same within the limits of its economic rights. So in 1992 itself, the Supreme Court recognized that, yes, it cannot be included as a fundamental right because of the economic limitations of the state. But yet, it has raised this right to livelihood as something which in a sense is part of Article 21, as we shall presently come to. In D.K. Yadav versus JMA Industries, reported in 1993, volume 3, Supreme Court cases, page 258, Supreme Court held that the right to life enshrined under Article 21 includes the right to livelihood, and the procedure prescribed for depriving a person's livelihood must meet the requirement of Article 14. That is, it must be right, just and fair and not arbitrary, fanciful or oppressive. In short, it must be in conformity with the rules of natural justice. Article 21 clubs life with liberty, dignity of the person with means of livelihood, without which the glorious content of dignity of a person would be reduced to animal existence. The principles contained in Article 39A and 41 must be regarded as equally fundamental in understanding the interpretation and the meaning and content of fundamental rights. If there is an obligation cast upon the state to secure to the citizens an adequate means of livelihood and the right to work, it would be sheer pedantry to exclude the right to livelihood from the content of right to life. The state may not by affirmative action be compellable to provide adequate means of livelihood or work to the citizens. The Supreme Court here clearly includes that the right to livelihood is part of Article 21, which is the right to life, because life is no longer animal existence, and the right to a dignified life is what is meant by the right to life. In Bandhua Mukti Morcha versus Union of India, the reported in AIR 1984 Supreme Court, page 802, the Supreme Court put the burden of proof on the respondent, stating, respondent being the employer, stating that it would treat every case of forced labor as a case of bonded labor, unless proven otherwise by the employer. The Supreme Court expanded the horizon of Article 21, held that the right to life includes right to live with human dignity, free from exploitation, and to have equal opportunity. Similarly, in the Asiad workers case, PUDR versus Union of India, reported in AIR 1982 Supreme Court 1473, the Justice P.N. Bhagavati held that anyone getting less than the minimum wage can approach the Supreme Court without going through the Labour Commissioner or lower courts. How far that would be relevant to bypass the existing tribunals is a different issue. But the question is, the Supreme Court recognized that livelihood was so vital to human existence, to Article 21, that you can directly approach the Supreme Court. That was the way this right of livelihood was raised, to the bar was raised. In Olga Tellis, now coming to the right to shelter. In Olga Tellis versus Bombay Municipal Corporation, reported in 1985 Supreme Court Cases, Volume 3, the page 545, the Supreme Court made a significant pronouncement on the impact of Article 21 on urbanization. We have seen livelihood. Now we see shelter. Deprivation of shelter would also inevitably lead to deprivation of the means of livelihood, which means deprivation of life. So along with livelihood, deprivation of shelter would also mean deprivation of life under Article 21. In Chameli Singh versus UP, reported in 1996, Volume 2 Supreme Court Cases, page 549, a bench of 3 judges of the Supreme Court had considered and held that the right to shelter is a fundamental right available to every citizen, and it was read into Article 21 of the Constitution of India as encompassing within its ambit the right to shelter to make life more meaningful. Shelter for a human being, therefore, is now not mere protection of his life and limb. It is, however, where he has opportunities to grow physically, mentally, intellectually, and spiritually. Right to shelter, therefore, includes adequate living space, safe and decent structure, clean and decent surroundings, sufficient light, pure air, water, electricity, sanitation, and other civic amenities like roads, etc., so as to have easy access to his daily vocation. The right to shelter, therefore, does not mean mere right of a roof on one's head, but the right to all infrastructure necessary to enable them to live and develop as a human being. So you find that along with the right to livelihood, the right to shelter is also now read into Article 21 of the Constitution of India. In now coming to the right of medical care and health and human dignity, in Sunil Batra versus Delhi administration, which is reported in 1978, 4 Supreme Court cases, page 409, the Supreme Court reiterated with approval the above observations that the right to life included the right to lead a healthy life so as to enjoy all faculties of the human body in their prime condition. It would even include the right to protection of a person's tradition, culture, heritage, and all that gives meaning to a man's life. It includes the right to live in peace, sleep in peace, and live in good health. In Paramananda Qatar versus Union of India, reported in AIR 1989 Supreme Court, page 2039, the Supreme Court has specifically clarified that preservation of life is of paramount importance. Once life is lost, status quo ante cannot be restored. It was held that it is the professional obligation of all doctors to the government or private to extend medical aid to the injured immediately to preserve life without any legal formalities being complied with the police. The Article 21 casts the obligation on the state to preserve life. It is the obligation of those who are in charge of health of the community to preserve life so that the innocent may be protected and the guilty may be punished. No law or state action can intervene to delay and discharge this paramount obligation of the members of the medical profession. In Paschim Bongo Khet Mazdoor Union Samiti versus State of West Bengal, reported in 1996, Volume 4 Supreme Court Cases, page 37, the Supreme Court said the Constitution envisages establishment of a welfare state and in a welfare state, the primary duty of the government is to provide adequate medical facilities for the people. The Supreme Court has insisted that government hospitals and medical officers employed therein are duty bound to extend medical assistance for preserving human life. Failure by the government hospital to provide timely medical treatment to a needy person violates his right of life guaranteed under Article 21 of the Constitution of India. But in a recent case, even where there were several legal provisions exist through which prisoners can secure medical care, but none have been used to ease the suffering of a 90% disabled professor. We'll come to the rest slightly later. I'll take a pause to summarize what we have seen till now. So Article 21 means right to life. It is guaranteed both to citizens as well as non-citizens. It includes, as per the dicta of the Supreme Court, right to livelihood, right to shelter, right to health. All these three aspects are considered a vital part of Article 21 of the Constitution of India, which is life and liberty. In Francis Corali Mullin versus Administrator Union Territory of Delhi, which is reported in 1981, Volume 1 Supreme Court Cases, page 608, Justice Bhagwati again has stated that we think that the right to life includes the right to live with human dignity and all that goes along with it, namely bare necessities of life, such as adequate nutrition, clothing, shelter over the head, and facilities of reading, clothing, shelter over the head, and facilities for reading, writing, expressing oneself in diverse forms, freely moving about and mixing and mingling with fellow human beings. A conjoint reading of the above decisions of the Supreme Court and the directive principles of state policies would indicate that the state has an obligation to ensure that the migrant labor in the times of this pandemic are ensured suitable food, shelter, health, transportation, both at their place of work and for moving back to the states where their homes. This must be understood and read as part of basic human dignity and an integral part of life under Article 21 of the Constitution of India. See, the whole object and purpose of discussing the earlier Supreme Court decisions is to see what the migrants have as rights, which are guaranteed under the most parent document of rights in this country, that is the Constitution of India. There are rights of livelihood, shelter, and health that are not recognized in Part 3, that is the fundamental rights. Yet they cast an obligation on the state under directive principles of state policy and have been clearly, in no uncertain terms and unequivocally read by the Supreme Court into Article 21 of the Constitution, which is the most basic of all fundamental rights that are there, guaranteed to both citizens and non-citizens in this country. The Constitution of India has guaranteed the freedom to carry out any trade or profession or occupation and business, that is under an Article 19(1)(g) under Part 3. But the right to shelter is not provided in the Constitution. Then the right of livelihood is not provided, as the right to shelter and livelihood and health are now part of Article 21. The judicial system will definitely take a positive approach to this and ensure that the migrant labor are provided these basic and elementary needs, especially during the time of this pandemic. There is another very specific reason why I have gone into some detail under Article 21 with regard to the rights of these migrants. Because there are specific statutes, laws framed by the legislature based on the dicta of the Supreme Court, or even otherwise, when the state understood its obligation under the directive principles of state policy, it has framed laws. We shall come to those laws later. But during this pandemic, when these laws cannot be strictly enforced because the pandemic, which has been enforced under the Disaster Management Act, the Epidemic Act of 1894 and 1897 or whatever, is to ensure that the COVID-19 does not spread does not spread uncontrollably in these countries. Yet, the need for control of COVID has to be balanced with the rights of these migrants under Article 21, and hence the obligation on the state. The plight of the migrants therefore raises constitutional issues that require strict scrutiny of the executive action, which has resulted in this situation. The core issues are protection of the fundamental rights of millions of these poor migrant workers to life and liberty, and the right to move freely throughout India and to return home with safety and dignity, which is guaranteed under 14, 19, and 21 of the Constitution of India. Let us now, therefore, look at the existing legislation that is there insofar as migrant labor is concerned. The first and most important legislation is the Interstate Migrant Workmen in bracket Regulation of Employment and Conditions of Service Act of 1979. This was passed by both houses of parliament, and the president gave his assent to the act on the 11th of June 1979. This act specifically defines migrant worker wages. I will not go into the sections of this act for the time being, but I will broadly outline to you what this act includes. This act applies to every establishment in which 5 or more interstate migrant workmen, whether or not in addition to the other workmen, are employed or who were employed on any day of the preceding 12 months. Every contractor, which I'm sure the expression contractor would also include, equally apply to the establishment, who employs 5 or more interstate migrant workmen, whether or not in addition to the other workmen, on any day preceding 12 months. The duties of contractors and establishment under the Act is to ensure the following: the name and place of the establishment wherein the workman, that is the migrant worker, is employed, the period of employment, the proposed rates and modes of payment of wages, the proposed rate, the displacement allowance payable to this workman. Most importantly now, the return fare payable to the workman on expiry of this period of his employment in such contingencies as may be prescribed, and in such other contingencies as may be specified by the contract of employment. Then it must, the contractor and establishment also have a clear list of the deductions that have been made on account of the wages paid to the workers. Such other particulars as may be prescribed to furnish to the state. Kindly mark this. The establishment and contractor who employs migrant labor is required to furnish to the state from which the interstate migrant worker is recruited, and also in the state where he is employed, a return in a prescribed form with a declaration that all wages and other dues payable to the worker and the fare for their return journey back to the state has been paid. The wages and conditions of service are also prescribed. We shall, at a later stage, after examining the other statutes, find that unfortunately and very surprisingly, none of the speakers on the rights of migrants have asked as to why this act has not been implemented in all the states where these migrant workers are working. Which are the establishments that have not declared their returns insofar as these migrant labor is concerned? What are the steps taken to protect these migrant laborers? What are the wages paid? What are the amount of amenities given? There are absolutely no questions being asked, and I shall reiterate this at the later stage, that unless post-pandemic, this is aggressively implemented by the state, not just by the central government, but by the states themselves who are using this migrant labor, you will find a serious problem for the economic condition of the state, because in the absence of these migrants, you cannot have your economy developing. You need this migrant labor, whether it's daily wagers, whether it's masons, whether it's plumbers, whether it's cooks. They have all gone back to their respective states. You are facing a crisis of a serious dearth of labor. I really do not know how you are going to run your economies again back and put your restaurants, buildings, and all your businesses back on track. Then you have the National Rural Employment Guarantee Act of 2005. Workers in rural places have provided 100 days guarantee of work during the non-agricultural season. The Act provides limited employment in rural areas under Manrega. Social security systems systems provide 9 types of benefits as defined in the Social Security Minimum Standards Convention of 1952, namely medical leave, medical care, sickness, maternity benefits, family benefits, unemployment benefits, employment, injury, invalidity, survivors benefits, old age benefits. Therefore, social security is the very foundation of a decent society. It's a primary source of social legitimacy. To what extent has this been implemented? We must see. Then you have the Child Labor Prohibition and Abolition Act of 1986. You have the Bonded Labor Abolition Act of 1976. You have the Maternity Benefits Act of 1967 and Equal Remuneration Act. Then you come to the Unorganized Workers Social Security Act of 2008. According to Section 2N of the Unorganized Workers Social Security Act of 2008, wage worker means a person employed for remuneration in the unorganized sector directly by an employer or through any contractor, irrespective of work, whether exclusively for one employer or for one more employer, whether in cash or kind, whether as a home-based worker or a temporary or casual worker, or as a migrant worker, or workers employed by households, including domestic workers with a monthly wage of an amount as may be notified by the central government and the state government, as the case may be. The central and state governments have brought in various schemes, social welfare schemes, for the benefit of the unorganized and migrant workers under the schedule to this Unorganized Workers Social Security Act of 2008. Let us see what these schemes are. The Indira Gandhi National Old Age Pension Scheme, the Janani Suraksha Yojana, the Janani Bima Yojana, the Aam Aadmi Bima Yojana, the Rashtriya Swasthya Bima Yojana, the National Scheme for Welfare of Fishermen and Training and Extension Scheme, the Handloom Weavers Comprehensive Welfare Scheme, the Mahatma Gandhi Bankar Bima Yojana, health and other insurance benefits. In 2019, the central government sought to unify, merge all the existing labor laws of this country under a common code and sought to evolve this with a view to streamline existing labor laws, occupational safety. Health and Working Conditions Code of 2019 was introduced in the Lok Sabha in July 2019. This code subsumes and replaces 13 labor laws, including the Act, and amongst others, amongst other things, it aims at to strengthen migrant labor rights. It provides that where any establishment is employing migrant labor through a contractor who is required to obtain a license but who has not done so, then the migrant labor so engaged through the contractor shall be deemed to be employed by the principal employer. It reiterates the provisions relating to entitlement of migrant workers to receive a displacement allowance equivalent to 50% of the monthly wages payable to him. Measures to discourage. Now, you have seen the existing statutes. You have seen these statutes obviously cannot be enforced against the employers and the contractors in this pandemic. But there are some guarantees that must be given by the central government and the state governments in view of the interpretation of Article 21, which we have already seen, which encompasses livelihood, which encompasses shelter, which encompasses the right to movement, health, and basic human dignity and living conditions. Why we are discussing all these is because we see that the migrant labor have been given all these rights by the central government. And yet we have a volume of litigation all over the country, and especially the Supreme Court in this regard. I would therefore first want the central government to look at the constitutional guarantees, and during this pandemic ensure basic human rights of shelter, transportation, livelihood, and we shall give some suggestions from our side at the end of this discussion. But one of the measures I would suggest first, some measures to discourage migrants to move back to their hometowns during the lockdown. The migrant labor is a vital part of the economy where they work. Today, when the lockdown is being eased out to facilitate resumption of economic activity, there is serious dearth of labor workforce in states like Delhi, Punjab, Rajasthan, Gujarat, Andhra Pradesh, Karnataka, Tamil Nadu. These states are facing serious shortage of basic semi-trained and skilled workforce. Please ask yourself, who is affected also with these migrants going back home? Why are they going back home? The principal reason is insecurity, because we at the workplace have not been able to guarantee the basic needs of these migrants. It may be financial, it may also be emotional. Have we given them that security? Because today, our economies, the advanced economies in the states that I've just mentioned, are going to take an equally bad hit for the absence of these migrants. There is thus a greater need for these states to ensure that the physical and emotional well-being of the migrant labor is taken care of. The measures need to be adopted inter alia are to strictly enforce the Interstate Migrant Workmen Act of 1979 and the Unorganized Workers Social Security Act of 2008. If need be, the states like Punjab, Rajasthan, Gujarat, Andhra Pradesh, and Tamil Nadu must make necessary changes in their legislation, in the national legislation that affects their states, because they should be concerned really with the absence of these migrant laborers. The states of origin may not be able to may not have the means to help the migrants. The central government therefore needs to fill in the gap. The central government, and I would also definitely state that the concerned state government where these migrants have been engaged and employed must, for their own interest, look at the interest of these migrants and enforcement of the 1979 Act and the 2008 Welfare Security Act. The current needs of the migrants and their plight. On the 1st of May, the central government responded to the rising public and political opposition to the migrant crisis by belatedly introducing special Shramik trains to urban migrants to go back to their villages. It is striking to see that their west to east routes, all these trains originate in states located in the western, southern, and northern part of India. Insofar as north is concerned, it is only Delhi. It is suggested that, and the Supreme Court has already said, and many states have already followed this, no fare should be charged to migrants during their travel from their home to their home states during the pandemic. The migrants must be supplied sufficient food, water, and facilities at definite intervals during these long train journeys to their homes back. The migrants must be ensured sufficient medical and health facilities. There should be sufficient food, medical, quarantine facilities, both at the place of origin and the destination of the migrants. I'll give you one example. In some states where the migrants return, whether it's Bihar or West Bengal or some or Orissa or some other state, not Orissa maybe, the migrants came home with a lot of hope that they want to at least stay in the time of crisis with their own people. But their own people in their villages did not allow them to come inside the villages because they thought they'd bring in the COVID, the corona virus into their villages. So the migrants were left neither here nor there. As in, unfortunately, pardon me for using the expression in Hindi, na ghar ka na ghat ka, as they say, they were left neither here nor there. The home states of these migrants are seeing a spike in the number of cases of COVID-19 during the movement. This must also be kept in mind. There is therefore need for the state of work as also the central government to ensure adequate medical and quarantine facilities, both at the place of where the migrant works. What the government agencies can do to ensure the securities of these migrants. Aggressively implement the Migrant Workers Act of 1979. This is possibly the third time in this discussion that I'm saying this. If this act is implemented, in addition to that, please ensure appropriate amendments to your state legislation where you will include and guarantee both financial and emotional security to these migrants. The central government has to announce free food grain for the next 2 months to the migrants who don't have ration cards with financial support. Most of these workers either who have left or are leaving in distressed conditions. You see, these migrants have not been paid. They are not likely to receive any money now. They are going back to their home states. The central government or the state government should ensure that some amount of money is passed on to their bank accounts under the various schemes that the central government has, and also ensure food grain and basic necessities of existence so that these migrant workers are able to live even at the place where they come from. Cash transfer to their bank accounts of the migrant labor for 4 to 5 months of wages. At the time of this crisis, the government should adopt a self-declaration approach for the poor people to access the benefits, rather than insist on credentials in the poor migrants, as has happened in some cities like Delhi. See, in some places, even for transfer and benefits of money, I can understand that the government wants some kind of an identification document or proof. But let us not insist on identification documents and proof for the purpose of transfer of basic food and food grain. Because every human being, Article 21 is guaranteed to citizens as well as non-citizens. Why I say non-citizens is because there is a recent report that came from Tamil Nadu of migrant workers from Bengal who are working there. They spoke in a unique dialect. They said they were from Murshidabad district of Bengal. But the persons who were extremely familiar with Bengali and various dialects, they found that these people did not speak the actual Bengali spoken in Bengal. They were migrants from a foreign country. You know which country I'm talking about. It is neighboring Bangladesh. But be that as it may, the government can take steps against the illegal entry of these foreigners at a later stage. But since Article 21 guarantees at least basic food, do not deny food to these people. Give them food. And please don't insist on produce or Aadhaar card, ration cards, and these cards. All right. This is one sincere suggestion from my side. Now, according to 2011 census, India has about 56 million interstate migrants, of which 40 million live in urban areas. Of these, roughly 34 million work in the informal sector. Roughly 79% of India's migrants work as daily wages in factories or construction sites. Looking at the recent crisis, government should seriously consider setting up an interstate migration council which can work towards the safety, security, and welfare of these migrants. This council will be able to resolve issues relating to interstate migration. More than 90% of the workforce is active in the unorganized sector in India and is without any permanent work or social security. Most of them do not have any identity proof which can establish their work status. In 2014, the government had promised to register 47 crore unorganized workers and provide Aadhaar-linked, non-transferable unorganized workers' identity cards on the lines of the Gujarat government, but somehow this has not yet been implemented. I sincerely request the state governments and the central government to take effective steps in this regard. Availability of such cards can be beneficial to all migrant workers, and the government could easily deliver benefits during this crisis. It is not possible now, but in future cases, whenever there is a crisis-like situation that this may arise, at least the government will have some kind of a document based on which it can pass on the benefits, the basic human benefits to these migrants. Then you could deliver Aadhaar card to establish a unique identity of every individual, and one nation, one ration card should also be implemented. This is the right time for a single portable card for the workers in the informal sector to be initiated. This card can work as an identity card as well as a benefit cum entitlement card. Both in normal times and during the crisis situation like COVID-19, an unorganized mechanism to serve the interest of workers can not only regenerate the confidence of the workers in the system, but also drastically improve the labor governance in the country. With 38.4% contribution by the informal sector, excluding agriculture, to the GDP, more targeted and inclusive policies for the workmen will bring better results for the economy. So these are some of my thoughts that I had penned down in the context of both fundamental rights and human rights for the migrant workers. Now, I hand over the proceedings to the college.
Sir, if you permit, there are a few questions. May I take a few questions?
Yes, please.
Yes, sir. This question was asked by our YouTube viewer, Legal Education. Question is it not the responsibility of trade unions to fight for the rights of migrant workers? If yes, whether trade unions are failing to perform their duty?
I think that's a very relevant and good question. Unfortunately, the trade union movement under the Trade Union Act of India is there, which is related to a particular industry, and there is a degree of permanency of membership of this trade union. The migrant workers are those who cannot be members of the trade union as they are working for a brief period of time in that factory or industry. If it is migrant worker who is in a permanent position, he obviously gets all the benefits from the trade union. So a trade union per se cannot come to the aid of all the migrant workers.
Okay, next very simple question. How can we share this information to the workers who are suffering from various difficulties in this COVID-19 pandemic situation?
This is also a very good question. I would sincerely hope that the media is able to first pass on the benefit, the rights to these workmen who are migrants. As I said, you should have pressure groups, you should have educative sessions with these migrant laborers. You should go to where they live and settle. You should educate them about their rights. It can start with students. It can start with groups from law colleges. It can start with other non-government organizations, labor association, labor welfare associations, and make sure these people ensure all their rights against the contractors and establishment under the Interstate Act of 1979 is at least availed by them. It will be the first step. Then they can apply for, these cards that, migrant labor cards, one nation, one card, and things like that. First is identification. Second is make them aware of their rights.
Thank you, sir. There are no questions. Now I would like to request Balarao sir to propose vote of thanks. Balarao sir, over to you.
Yes, Bhalerao sir.
हाँ मैडम, एक मिनट.
Honorable Lordship has really given very, very important suggestions and valuable suggestions and focused on the complete area which is covering the rights of the migrants, constitutional rights, legal scenario, and also have focused on case law. Bhalerao sir, you can proceed for the vote of thanks. Please go on, sir.
Yes. Balarao sir, can you hear us?
Yes, if Bhalerao sir is not able to, then I will continue. May I? On behalf of N.B. Thakur Law College and Gokhale Education Society, I really appreciate your efforts taken for giving so detailed study of it. I'm thankful to you, Honorable Rajasekhar Mantha sir, for taking and giving us so much of time. Thank you very much. Now I think we all will go for National Anthem.
Yes, ma'am. Yes, ma'am. Sure. Give me 1 minute.
Yeah.
Let me if it is audible or not.
Okay, should we start? Should we stand? Yeah, all are requested to stand.
Yes, ma'am.
गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे. Thank you all.
Thank you all participants. Madam, over to you.
Yes, thank you very much, sir.
Thank you.
And thanks to all the participants.
Thank you, everybody. I think